Hey guys, my name is Gabby Zanis and welcome back to Gov with Gabby. Today we're going to be talking about Wisconsin v. Yoder. This is a required court case for the AP Gov curriculum. So let's get right into it. This case took place in 1972 when Jonas Yoder and two other Amish parents are prosecuted under the Wisconsin law. Why? Well, because they decided to take their kids outside of school before the age of 16. Under Wisconsin law, it was required that all students attend high school until at least 16 years of age. But the Amish people said that it went against their religious beliefs and therefore violated the First Amendment. These three parents refused to send their kids to school past the 8th grade because they wanted their kids at home learning the ways of the Amish. But the Wisconsin law required them to attend school. The evidence shows that Amish, yes, do provide their own informal vocational education to their children after 8th grade, but still they were prosecuted under Wisconsin law. In a time when these Amish children should be requiring all of the knowledge and skills to prepare themselves for an Amish way of life, they were stuck in high school, which to Yoder and many other of the Amish parents went against their religious beliefs. The big question for this case revolved around the free exercise clause of the First Amendment. Let me say that again. The free exercise clause of what? The First Amendment. This is all about one's ability to freely exercise their religion. Get it? Free exercise clause. Well, pretty much, the big question was, does this Wisconsin law requiring students to attend school until the age of 16, does it violate the free exercise clause of the First Amendment? And thus, does it criminalize the conduct of the parents who refuse to send these children to school for their religious reasons? Well, let's see what the Supreme Court said. The Supreme Court ruled 7-0 in favor of Yoder, saying that yes, this Wisconsin law does violate the free exercise clause of the First Amendment because there's two things that they had to weigh. One, the rights and the individual liberty of the religion and their freedoms under the First Amendment, specifically the free exercise clause, versus the Wisconsin's genuine interest in educating knowledgeable citizens. The Supreme Court ruled that Yoder held more weight, so his reasoning, his argument, the fight for individual liberty and religious freedom, it outweighed Wisconsin's law and Wisconsin's desire to create educated citizens. Many wondered if these 2 years that the students weren't in high school would significantly impact their ability to become upstanding members in the community. Well, the Supreme Court said that they would not, because most Amish children become self-sufficient members of a society with excellent records as law-abiding citizens. Wisconsin v. Yoder, 1972, is one of the most important Supreme Court case decisions. Why is it one of the most important Supreme Court decisions? Well, because it is the best example of a free exercise clause favoring minority religion over state law. Minority religion, the Amish, over state law, Wisconsin's law. Therefore, free exercise clause, it expanded the power of the First Amendment, specifically the free exercise clause and rights to personal religion. And this case was just a defining moment of, yes, we're going to give you your freedoms. We're going to give you your liberty because you're entitled to believing your religious beliefs and being allowed to carry them out if they don't significantly impact the community. And in this case, they did not because the Amish received their own vocational learning and the Amish had an excellent record of being upstanding citizens. So, we just learned a lot. Let's do a really quick overview. First, Yoder, he said, no, I don't want to send my kids to school past the 8th grade. It violates my Amish beliefs. Wisconsin was like, no, you need to send your kids to school so they can be upstanding citizens and learn and be involved in the community. So you must send them to school until they're at least 16 years of age. But Yoder was like, no, that violates my religious beliefs. And under the free exercise clause of the First Amendment, I should be allowed to believe whatever I want to believe and exercise it how I see fit. Wisconsin was like, no, you need to send your kids to school because education is foundational to America. Then Supreme Court case went all the way up to the Supreme Court. Supreme Court ruled 7-0 in the Burger Court in favor of Yoder. They said that yes, Wisconsin did have a genuine interest in educating their citizens, but Yoder's need for religious freedom under the First Amendment, the free exercise clause, that outweighed Wisconsin's genuine interest in educating the citizens. And this Supreme Court case is so important because it is the best example of the free exercise clause favoring a minority religion over state law. Thank you guys so much for watching. If you loved this video, learned a little something, or you just love AP Gov, make sure to subscribe, like the video, and turn on notifications because I'll be posting more videos of the required Supreme Court cases for the AP Gov curriculum. Thank you guys. Bye.